Good afternoon, California members. My name is Alexandra, and I am the Director of Education at the American Apartment Owners Association. We're really excited to have you guys here. Some of you may have already seen Brewer, Offord, and Peterson LLP with Ashley and Adam, who came not too long ago to do another webinar, but we have them back today. The last one was pretty successful. And before we get started, I just want to talk about a couple things. One is that we're going to have about 45 minutes to maybe 50 minutes of talking time, and then afterward we'll have a Q&A. So save your questions for the end. There will be a place, if you can see it now, where you can actually enter in your questions. I don't have the presentation for you right now, but I will be emailing it to you guys tomorrow as well as the recording. So take notes, but you're going to get everything tomorrow regardless. And lastly, we currently have actually a poll, but before we do that, I'm going to just quickly go over Adam and Ashley's bio for those of you who haven't heard from them yet. So Adam is a senior partner and real estate attorney at Brewer, Offord, and Peterson LLP. He has about 8 years of experience as an advocate for real estate brokers, landlords, property managers, and agents. He's a licensed California real estate broker as well, so he's very familiar with issues about real estate transactions, non-disclosure disputes, agent responsibilities, close of escrow issues, and title disputes. He went to law school at Santa Clara University and currently serves as the 2018 co-chair of the real estate section of the Palo Alto Area Bar Association. And Ashley is a junior partner and attorney at Brewer, Offord, and Peterson LLP. She helps real estate investors, homeowners, landlords, agents, and brokers, which is all of you guys on the call today, with issues relating to partition actions, unlawful detainers, duty of care disclosures, and other real estate legal issues like the one we're going to cover today, marijuana laws. Ashley is also the 2018 co-chair of the Palo Alto Area Bar Association Real Estate Section. So with that said, we're really excited to have you guys. And before we get started, I'm going to pull up a poll question that they have actually put together to get a better feel of kind of where you guys are at with this topic, new marijuana laws. So I'm going to go ahead and launch the first poll question. And I'd love it if you guys on the call could participate. The question is, have you ever received a tenant request for accommodation related to cannabis use? So yes, for recreational use, for medicinal use, or for both, or no. So I'll give you guys about another minute to respond. I'll wait till at least we get at least 75% of you who voted. Looks like I'm seeing the votes come in. All right. And I'm going to share the results. Adam and Ashley, can you see the results on your screen?
We can.
Yes, we can, yeah.
Yes.
Great. Do you guys want to talk about a little bit about what you see here so far?
Yeah, it's interesting. I'm not surprised that we see more medicinal requests than recreational just because before the legalization, I think that was a bigger priority to tenants, people that have certain diseases or disabilities that cannabis helps them. I can see them asking the apartment owner or landlord to do that. Recreational, obviously, I think will increase, but it's definitely interesting, and it seems like a majority of you haven't received requests, so that tells me a lot as well. Tenants, I think, are a little bit timid to bring the subject up, and they may just be keeping it to themselves.
Yeah, that would be my guess. My guess is that one of two things. One, that either the tenants don't want to bring it forward as an issue because they don't want to be told no. And I think number two, and this is something we'll dig into a little bit more deeply later on, which is that there may be an assumption amongst the tenant population that there is no need to consult with the landlord regarding this particular issue, which is actually not true. But again, we'll get into that later on. But that would be my guess, is that there's an assumption that no request is necessary.
Good point.
Okay, I'm going to go ahead and pull up the second one. How often do you have cannabis-related issues with your tenants? Never, rarely, sometimes, most of the time, or all the time. I hope not, but uh, it could happen. All right, I'll give you guys a little longer to answer. I know we're going through them a little quickly here. I want to make sure you have a chance. We also have a lot of you coming in as we speak, so if you just got onto the call, still vote.
And we promise you, it's only going to get more interesting from here. So, feel free to. Only
I mean, I think this is interesting. All right, here we go. You see the results?
Yes,
Yes.
it's less than the prior one. 70% had never had a request, but still kind of high. I'm surprised by that. And I'm also curious of what issues you have had for the ones that selected rarely. So feel free to put in questions in the chat, and we'd be happy to answer those if we can. Most of the time, 5%. I'm sorry about that.
Right.
But we can help you if you need help with that. But it's very interesting.
Yeah, I'm just totaling it up there, and I'm certainly no math major by any means, but it looks like about 53% have confronted cannabis-related issues. So the majority of you have confronted these issues. So it's I don't know that it's necessarily a problem, but it's certainly a topic to be dealt with, given that the majority of you do face some type of cannabis-related issues with your tenants.
Okay, let's go on to the last one. Have you ever included a provision in your lease, form or addenda, related to cannabis? Never, a few times, many times, or always? Okay, let's see the results.
Oh, yeah, that's very interesting. We can see the results here, and hopefully those of you out there can see them too. This actually doesn't surprise me. Probably doesn't surprise you either. And I think it's something that probably needs to change. I mean, it's close to 60% of you out there who don't specifically address cannabis use, and I would include in there cannabis use and or cultivation is something we'll get into a little bit later today as an important point to address in leases. The standard form leases don't typically address it. I don't believe the CAR form at this point addresses it directly, and it certainly is an issue that I think warrants some level of consideration in any current California lease agreement. So we'll get into some things that I think landlords or property managers may want to consider including in their lease documents a little bit later. But yeah, I'm not totally surprised that it's 60% that does not address the issue directly.
Yeah, I go to the CAR legal forum every year in Sacramento, and it's come up a few times, but more jokingly than seriously. And I hope that maybe this year or soon they start thinking about an additional form or addendum where they have template language, because part of the problem for you guys on the call here watching the webinar is a lot of you do not have a law degree, and to draft language, custom language for a lease is very difficult, and you're putting yourself in a corner in a sense that if you don't put the right language, you can really cause some problems. So I think they need to administer a form or language or change the lease itself, but I think it might come down the pipeline.
Right. And to be sure, while it is a highly funny topic sometimes, it's also one that warrants some level of seriousness and consideration. Although I'm sure that today's presentation will be bereft with corny jokes regarding cannabis use. I can promise you that.
Well, I don't mind. I'll go ahead and hide the poll, and you guys can get started. We can see your screen, and we can see you, which is great. I didn't mention that this is the first time we've had a video aspect here to see our speakers, so I'm really glad you guys set that up today. But take it away.
All right, so just to get us started, as you know, we're going to be talking about the new marijuana laws and the impact on rental properties in California, some things to look out for. Basically, what we'll do is we'll trot through a quick history of cannabis in California, both medical and then recreational, which is the most recent change in the law. And then we will get into some of the things to look out for, some of the concerns that we get. We often get, phone calls, emails from landlords and property managers when this issue comes up, and there's a few common contexts and when this issue comes up that we'll look at. And then we'll talk about some of the consequences or some of the negatives that can happen if you don't deal with the issue, or if a tenant is not conforming to whatever rules that you may have regarding cannabis. So first of all, the disclaimer. I've already given you my disclaimer regarding my bad jokes, so that's just keep that in mind. You can read through that. Basically, this isn't legal advice. Every situation is different. In all seriousness, if you have an issue, it's a case-by-case analysis. That's one of the things that we do. And so anybody can give you general information about the law, which is what we're going to do today. But really, if you've got an issue that you're confronting, just the slightest change in facts or circumstances can really change the outcome or the advice required to get it done. So please do not rely on this for your specific circumstances. So with that said, jump right into it. We've gone through our poll questions, and so I'm going to turn it over to Ashley to give us a quick overview of the history of cannabis in California.
Right. We wanted to give you an overview so you have a good grasp on the law in California. That way when we focus on real estate, you understand why the rules are the way they are and what the state has done to legalize compared to federal law. So with that, we'll start with the landmark proposition. I'm sure you saw in the news January 1st last year. People were allowed to use cannabis recreationally. If you're 21 and over, you were allowed to possess and use marijuana either in your private residence or in a business that is licensed to allow that. Proposition 64 works hand in hand with Senate Bill 94, where that passed in 2017 and went into effect in 2018, and they work together. Proposition 64 legalizes it, and then Senate Bill 94, what they do is they give local counties and cities full authority to regulate as they see fit. They can regulate mostly commercial use, but they also can regulate personal use, and we'll talk more about that in relation to the real estate context and tenants. The Federal Drug Enforcement Agency, for some reason, they still consider this a Schedule I drug, so please keep that in mind as an owner or a property manager, that regardless of state law, federal law, cannabis is still illegal and it's as high as a Schedule I. So it's a pretty serious offense. Just for current events and just so you get a feel for the magnitude of the conflict wherein I state Proposition 64 legalizes cannabis use in California and now it's still illegal federally, there's been some crackdowns in Calaveras that have been pretty serious. One example is in Calaveras County last year. Legalization became a big hit in Calaveras County, and a bunch of people were buying up land there, acres and acres. We had one person we knew that bought 300 acres to cultivate, and the county gave out all these permits and licenses for commercial cultivation, manufacturing, and then about 3 or 4 months later, the county changed their mind, probably because of politics or some other reason, and revoked all the permits and licenses. So these people were left with all this land and essentially nothing to do with it, and they had 6 months to close it down. So that's one instance where a lot of people are affected, and it's pretty serious and shows you that if you're getting into this business, if you're a landlord renting to a tenant that wants to cultivate or grow or do anything like that, federal law doesn't care. They can crack down whenever they want, but also the local city or county has the ability to change the law whenever they want as well. So you're dealing with uncertainty here. Also, last year in Northern California, Sacramento area, the federal government seized over 100 homes on a crackdown. These homes were basically caught cultivating cannabis, in some ways legal, some ways illegal, but the federal government doesn't care, and they came in and they seized the property, and you're probably thinking, oh my God, how are they allowed to do that? And if you see on the screen, it's 21 U.S. Code 881, what that code says, you can look it up. It's a pretty demeaning code, at least to people trying to get in the business. They can seize your property without any compensation if you're involved in any Schedule 1 activities. So if you have a tenant that's growing a plant in the backyard, technically the federal government can come in and seize your property and deed it away from you, and they don't have to give you a dime. It's unlikely, and I think Adam can agree, but it makes you understand the risk of getting into this business and allowing tenants the freedom to do that, and understanding that federal law can cause you to lose your property or your client's property. Next. Okay, how did we get here? Before 2013, the federal government had more of a standoff approach, and they basically said the states can do what they want. They can regulate cannabis as they see fit, legalized or not. But in 2013, the Cole memo was revoked by the Attorney General Jeff Sessions at the time. And what happened was that the Controlled Substances Act was reinstated, and this is where that prior code section comes in handy, and it made marijuana a Schedule 1 drug, trumping state law. So that's pretty substantial, and that's why they still have the ability to crack down. Before, the Cole memo gave states some form of immunity from federal enforcement.
Yeah, when the Cole memo was in force, there was some reasonable expectation on the part of states and more importantly, people operating within the cannabis industry within those states where it was permissible, that the federal government wasn't going to strictly enforce that law. Now that's clearly off the table, and there certainly has been since then an increase in enforcement action by the federal government.
Right, and it's interesting, if you look at the date, January 4th, 2018, it's shortly after California legalized recreational use, so I don't think it's any coincidence that occurred at that time. It's, they flexing their muscle, so to speak, and saying that they are going to run it their way. Medicinal versus recreational, despite legalization, permitting and licensing is difficult regardless of either way you do it. For state law, especially since Senate Bill 94, I talked about prior, it gives local, county, and agencies the authority to regulate how they want. Just because it's legal in the state doesn't mean you can do anything you want with cannabis where you live. That particular city or county has to allow cultivation, manufacturing, sale. So, for instance, we're in the Bay Area. There's very few cities that allow cultivation or manufacturing. It's limited to, say, San Jose, San Francisco. There's a lot of cities, even though it's legal in the state, the local counties, cities regulate that pretty heavily.
Yeah, it's particularly true with respect to commercial retail sales as well. There's only a handful of cities, at least using the Bay Area as an example, that allow the retail sale of cannabis products. So you can go, to use Oakland as an example, I think it's probably one of the more extreme examples, you can be in Oakland and be downtown Oakland, and there's, a number of dispensaries, easily accessible to you, where you can go one town over and it's completely illegal to sell. And so, a matter of 10 feet can make an incredible difference as to what the law is with regard to commercial cannabis. And so, from a standpoint of, those involved in property management or the purchase and sale of multifamily properties, especially those that may have a mixed commercial component to them, it's really important to know what your local laws are, and they do change frequently, as Ashley noted before.
Right, and for recreational use, which is more relevant to probably your interests, local government can regulate, but they can't totally ban certain activities. For instance, they can't ban completely personal possession in small amounts. That is legal regardless in the state. Your city or county can't say you can't do that. They also can't ban indoor cultivation. They can put restrictions on it, say that, you have to do it, and it has to be in the outdoor unit of the home. It can't be in the main part of the property, or some people like to grow outside. they can eliminate that and say, no, you have to do indoor growing. They can't ban growing or personal possession in the property, but they can regulate it. So that's some restrictions. And there's other restrictions not really relevant to this group regarding public access roads, that type of thing, but that's a whole nother topic. And then on to HOAs and apartment owners. We've actually seen some CC&Rs adding provisions about banning cannabis, the use completely. How you enforce that, we'll talk about that later. But we've seen more HOA boards that are paying attention to the law and really trying to be innovative. They've added it into the CC&Rs, and they're allowed to do that, even though it's legal, in the state, and even in that county or city, the HOA has the power to ban it in their organization. So does the apartment owner, regardless of legalization or tenant need, they can ban it. And that stems back to the federal code section I showed you, because the apartment owner or the HOA has a lot at risk. If they allow it or forced to allow it, they're at risk of forfeiture. So they are given a right under the law to ban it should they see fit. Next, restrictions that come up. Again, based on the risk of forfeiture, the law allows them to ban it, regardless of use. I know there's a lot of sensitivity for disabilities and people that use it for cancer and that type of thing. Unfortunately, those people still don't have a right. If they're a tenant, the owner, HOA, can ban it. Whether or not they're doing it is another story. As a tenant, I think there's ways that you can resolve that issue. I think a lot of apartment owners are concerned about the smoke and the smell and the nuisance to other neighbors and regulating that, because if you're getting complaints from the people that are using, that's a whole other issue too. I think there's other ways you can take it, by way of eating it or oils. There's a bunch of solutions, but I think that as an apartment owner, HOA board, or just a landlord itself, I think that you should understand that you're allowed to ban it completely, but enforcement is another issue. Again, just list some reasons on why you're allowed to ban it completely. I think that the law might change on this. We'll see. I think based on the health benefits and the research that's going to be coming out, now that it's legal recreationally, that may change. Again, this all comes down to politics and who lobbies for these changes. So we'll see how that works out. There's a lot of people that own property that don't want it to be permitted no matter what, and then tenant activists that want some kind of exception. So we'll see how that goes down. And if you are going to ban it as a person on the HOA board, apartment owner, landlord, we recommend doing an addendum to specify the ban, because as we discussed, the lease has no mention of cannabis use, and you don't want to just assume that the tenant knows it's illegal federally and they're not going to do it. You want to make it in writing where they agree to it, they consent to that, they're aware, and then there's no issues about understanding and meeting of the minds, so to speak. Next. Okay, common restrictions continue for individuals under state law. You're allowed to grow up to no more than 6 non-medical cannabis plants, no matter how many people live in the apartment. So if it's 4 people that have an interest in growing, you're going to have to share the use. It's not 24 because there's 4 people. It's 6 per unit, and that's if the landlord or apartment owner allows it. Also, as I mentioned before, counties and cities can regulate, but they can't ban it completely. That's really up to the people involved in the lease. That comes down to you, because the county or city, you can't rely on them to ban it because they can't by law. Next, for counties and cities, this is a big one. May not be totally relevant to residential properties, but I think it's interesting. The counties and cities can actually control who gets licenses to grow or sell or cultivate, and that is substantial. For instance, in the city of San Jose, if you go on their website, they actually put there that they are not accepting applications for any commercial cannabis activities. So they sort of have a bottleneck going on, and I just think that's interesting to know and to follow, because if it really opens up commercially, I think that will have an effect on the residential area.
Yeah, or like I know in unincorporated Alameda County, for example, county's only currently issuing 6 permits for cultivation in the unincorporated area. And again, they control how it's cultivated. It can only be grown a certain way. And I think either 2 or 4 of those licenses out of the 6 went to pre-existing medicinal dispensaries that had converted to recreational use. So a pretty tightly regulated industry at this point in the Bay Area, even where, and I imagine the Bay Area is probably a little bit looser than other counties that are more conservative, and still you see very tight control.
Right. So next slide, we're going to talk about the sale, and that's relevant to you guys, because I think tenants can get the wrong idea. They think that they're growing 6 plants in their unit, that they're not going to use all that. Let me make a profit and sell that. Well, actually, under Health and Safety Code 11359, it's a felony in California to sell cannabis or have the intent to sell without a license. So that's it's across the board, universal. That law doesn't change in any local government. So if you have a tenant and you do want to allow them personal growth, you really have to make sure that they are selling to their friends or selling to dispensaries, because that is completely illegal. It's a felony, and typically if they do that, they might get flagged federally, it might get on the radar, and then you're in trouble as the owner, or your client will be in trouble, and that's the last thing you want, because again, they can seize your property without any compensation.
Right, that's important to note. I mean, otherwise, legal activity under California's new law can quite quickly become illegal, both under California law and federal law, and that's really where I think you're going to see a lot of the enforcement happen. The federal government, even with the withdrawal of the Cole memo, seems to have been a little bit more deferential to people who mind state laws in the commercial cannabis sector versus those people who are really just drug dealers. I mean, there's no other way to describe it. They're just, slanging drugs on the side. That's not what the state law envisions, not even close, and it's not something that I think the state is going to shield landowners from if they're allowing that activity to go on.
Right, and I think that you have to be careful if you are more open-minded and you want to have your tenant doing that. I think there's a loophole in there for enforcement or for law enforcement where you can grow 6 plants, and if you harvest that all at once, you may be above the personal possession limit at that point, and they may say, hey, you have way too much for personal use, so we think that you're just growing to sell. So I think it's riddled with potential problems, and you have to be really careful. I think that use alone versus cultivation in the home is pretty different. So you just have to decide as an apartment owner, landlord, manager, whatever it is, how far you want to go and understand the risks involved. So I think that overview of the law will give us the basis to talk about now marijuana and rental policies.
Sure.
So Adam will take that over.
Yeah, so looking at policies or procedures for the use and cultivation of cannabis with regard to apartment owners. So I'm going to just go through some proposed lease terms and addenda that you may want to consider if this is an issue that you're looking at. I think I can be pretty unambiguous as to what my position on the issue is. And from a strictly, objective risk-benefit, perspective, having leases that prohibit the use and cultivation of cannabis on the premises seems like kind of a no-brainer. There's really not a lot in it for the landlord, and the negatives can be quite substantial, as Ashley's already pointed out. The law provides for forfeiture of property if somebody on that property is abusing state law and stepping outside the bounds of state law in their use or cultivation or sale of cannabis. So by way of example, most leases already deal with cigarette smoking. There's a section in the Civil Code, 1947.5, that specifically allows a landlord to prohibit smoking in any building, portion of the building, dwelling unit, inside or outside. And so broad authority to the landlord to prohibit cigarette smoking.
Right.
That's a long-standing provision of the law, or relatively long-standing anyway. And so the question that we often get as well is it the same with cannabis, because now people hear that, hey, people have this right to use cannabis, and, even the cities and the counties who have most of the control over cannabis can't restrict personal use. So can I, as a landlord, do that? And the answer is yes, you absolutely can. And for lots of reasons. One, by way of analogy from the cigarette smoking provisions, it seems pretty apparent that even prior to the enactment of Proposition 64, and I think it's SB 94, correct? The general consensus among the law was that you had that right as a landlord anyway, based kind of on the analogous law with regard to cigarette smoking.
Mm-hmm.
And then also based on the fact that it's federally illegal, and generally as a landlord you don't have to permit illegal conduct to occur on your premises. So that was sort of the answer before, but thankfully Proposition 64 has made it pretty clear, and there's a provision within the Health and Safety Code that's part of Proposition 64 that specifically allows a private landowner to prohibit cannabis use and cultivation on their property. So it's absolutely allowable, and I think that it's something that with respect to your lease and or an addendum to lease, something that you want to address specifically. Because I don't think, and this goes back to our polling data, I don't think your average tenant knows or understands that when you say no smoking, that it incorporates necessarily marijuana use.
Right.
And I think more importantly, the cultivation aspect is something distinct from cigarette smoking, where the typical provisions of the lease just don't cut weight. They're not sufficient to address that issue. Why? Because most people don't grow their own cigarettes in their closet. I've never seen anybody with a tobacco farm in their bathtub, so I don't think it's an issue, right? But with respect to pot, tenants do grow pot, and so I think that needs to be dealt with, because that, on some level, can be even more problematic than smoking it, and for lots of reasons. Number one, it's easy for the tenant to exceed state law by growing more than 6 plants.
Mm-hmm.
Number two, if they do, you invite the possibility they're going to sell that, as Ashley said, which is even more illegal now. They're selling it out of your unit. And number three, its growth creates environmental problems that aren't really present if the person is using cannabis, even if they're smoking it, because cannabis plants require high humidity. They use a lot of water. And I can't tell you how many cases I've dealt with, probably Ashley, you too, on both a landlord-tenant perspective and then a purchase-sale perspective, where property has been damaged by cannabis cultivation, in the form of mold, water damage, and otherwise, and then the subsequent owner or subsequent tenant gets into the property and realizes that there's all these issues, and it's because somebody was previously cultivating marijuana in there. It can be a big problem. So the current form leases that are out there, I don't think adequately deal with it. Maybe there's some that I've not seen, but typically no. So I think it's definitely something to address head-on in your lease.
And one thing to note, I think a lot of apartment owners, property managers are timid from saying we don't allow cannabis on either advertisement or when they deal with the tenant, because everyone's scared of just discriminating. So, for instance, we've had a lot of pets, right? Pet issues. If you have a special need where you need a service dog, well, the law is super strict on that, and you can't say in advertisements, hey, we don't allow dogs. You have to caveat that on acceptance of service dogs. So don't think that you can't advertise it or be very explicit that you don't allow it, because it's not going to be seen in the same light. It's not going to be seen that you're discriminating against people that need it for their health. So just don't be fearful of that. I think that's important to know.
Yeah, and I'll get into a little bit of the specifics about discrimination law and the intertie with cannabis, and specifically medical cannabis, is where that normally comes up. But looking at what you can do then, if we assume that it's in the lease, we've got it documented, we've got signed addenda or lease terms that provide for the prohibition on this activity. Okay, well, what happens when it comes up? Is this a cause for eviction? Answer is yes, it is a cause for eviction. Let's look at it from a couple different angles. Consuming cannabis versus dealing drugs. And this goes back, again, to the law and its limitations on sale, all of which are the same as they were before the allowance for recreational pot, right? Licensed retail sales is very different than, selling it out of your garage or your apartment. That is just dealing drugs. And so the important thing to note there is that just because cannabis is legal doesn't mean that you as a landlord may not have to take action on that issue, right? If someone is dealing drugs, including cannabis, out of your apartment or out of your home, and it's potentially causing a nuisance to neighboring tenants or neighboring landowners, you, under the law, as the landlord or property manager, have an obligation to take action to mitigate that activity. Yeah. And response by the tenant or the offending party that, cannabis is legal now is not sufficient. Right. You've got to take action, because dealing drugs is still dealing drugs, and if it's happening on your property, you've got to deal with it. So there's that. Secondarily, okay, what do you do if you discover they're breaching the lease? Maybe they're not dealing it, but maybe they are growing, and maybe it's even within that 6-plant limit. Well, if you've prohibited it, that's your right, and you've done it in the lease, you've got it signed, and so you can then, just like you would for any other violation of the lease, issue a cure or quit notice or a 30 or 60-day notice, depending on your jurisdiction. Be careful for those of you in rent-controlled jurisdictions, because that's going to come into play here too. But if it is activity which is either illegal or contrary to the lease, you can definitely serve a notice and definitely proceed with eviction. As you all know, you have to be really careful about the kind of notice you serve, timing, the contents of the notice, and all those things. Certainly, we'd be more than happy to help you out with those issues if you need it. But long story short, just because it's legal doesn't mean you cannot evict because they're violating the lease or the law.
Right.
Touch briefly on the purchase and sale of property next. I know most of you probably deal in property management, maybe not necessarily a lot of sale stuff, but for those of you who are brokers or agents, you may get involved in this, including the sale or resale of multifamily property. I've done a lot of work to do with disclosures. It definitely can be a disclosure issue on a few different levels. Right. I've already kind of touched on one of the bigger ones, which is, hey, if I know that this unit or this home has been used previously in cannabis cultivation, is that a disclosure issue? Answer is absolutely. I've dealt with some cases just recently where the former occupant was growing cannabis on the inside of the premises, and then the property sold. No disclosure was made, and there was mold discovered in the premises. It's a pretty common fact pattern that we see these days. And so if you, as the seller, know that this was going on, it's definitely something you're going to want to disclose so that that buyer at least has that information. And if they then don't take action on that information, that's no longer your issue. A couple of the ones that I think are more nuanced that are coming out now are what I would call environmental disclosures related to cannabis use or distribution or cultivation. And that is, what if you have a property that's located next to a warehouse wherein cannabis is being cultivated, or next to a dispensary wherein cannabis is being sold? That could raise concerns for the person looking to purchase that property or the future tenant. And so that may be a disclosure issue with respect to neighborhood conditions that the buyer would want to evaluate.
We get hypersensitive tenants where if you're next to a warehouse and they're going to complain that they smell it, or it's certain clientele next to a dispensary. So as a broker, just even as a property manager, you should tell the tenant, hey, just so you know, it's totally legal. They have a license, everything like that. Half a block down, there's a dispensary that's pretty popular, and so on. I don't see any reason why you should not say that. There's more problems that come with not saying anything. Yeah,
and multifamily properties especially, it's not an issue that I see as much, but it's an issue that I've experienced myself, where you've got mixed-use projects or developments. I, when I was in law school, looked at an apartment in San Francisco. We were considering a move up that way. my wife was in school at UCSF at the time, and so we were looking in these apartments, and we saw one that was above a dispensary.
Yeah.
And I didn't have a lot of concerns, but, it was a little, unsavory from the outside, if you will. And then I got up into the apartment, and it reeked. Like, it literally reeked of marijuana. And I think that would be an issue that you would need to work through with any prospective tenant. Now, you could turn it into a selling point. Obviously, you would sleep very well if you were to rent there. It would be a nice place. You'd get lots of rest. You might eat too much. But, I think it's an issue for tenants. And mixed use with cannabis, I think, can be problematic. So flipping to some of the common issues that we see here in practice, we've touched on these a little bit already, but this one is more specifically what Ashley was referring to before, which is medical accommodation. And you'll hear this a lot from tenants. And if you Google this, you're going to get a lot of conflicting information, because people who use medical marijuana really want it to be treated as a prescription drug. And we don't need to get into politics as to whether or not that should be the case, but it is not the law currently, right? The courts have relatively uniformly to date said that it is not a medical accommodation issue. So for federal law goes, under the ADA, or the Americans with Disabilities Act, does not require accommodation. I think that was pretty obvious. It's still federally illegal.
Yeah.
It's a Schedule I drug, so not going to require accommodation. And there's some case law that I put in there you can look at if you feel the desire. In California, there's not been a lot of specific cases on it. I cite a case down there, Ross v. Raging Wire. That's a case dealing with medical cannabis in the employment context, but it is under the same body of law, which is the Fair Employment and Housing Act, that decision was made. So the people, in the industry suspect that it's going to be the same result, that, you're going to see that it's not an accommodation issue under the state law either, because for the same reasoning that employers and likewise landowners shouldn't be forced to allow otherwise illegal activity on their watch. So I don't see that changing anytime soon. However, just getting ready for today's presentation, there have been a couple decisions in other states that swing the other way. So it really, I think, is going to depend on the political acceptance of legal cannabis and how that plays out. And Ashley talked a little bit about this before. Enforcement. How does these rules get enforced at the end of the day? Well, the most grave enforcement mechanism I think that you're to be concerned about, and this goes directly to my opinion as to whether or not landlords should consider prohibiting cannabis in their leases, is that the federal government can take your property away. And I give an example here. There's a dispensary named Harborside. They're probably one of the bigger known dispensary operators in the Bay Area. I think they have a location in at least San Jose and Oakland. Super big. This is a $20 million a year enterprise, quite literally. That's their take. Probably more, because that number comes back from when this case was happening, which was a few years ago. So if it was $20 million 5 years ago, imagine what the revenues are looking at for them now. I mean, this is big business. And they were a tenant in a commercial building. That's where they were operating their dispensary, and the federal government came in and seized the property. And the landowner had a hell of a time getting the property back. Now, thankfully, it kind of worked itself out in the wash in this particular case, but it took a couple years in federal court for that to happen. So not somewhere you want to be. So, again, an issue better addressed up front than left for, federal enforcement.
Yeah, I think if I do recall correctly, the court doesn't exempt landlords from liability. They assume just due to the nature of the business. A lot of people dealing with it, tenants and commercial tenants, they deal with cash and a little bit under the table. So there is just a presumption that the landlord's involved in some way, or even the property manager. So, even if you think that, hey, I'm not involved, I don't know anything about the business or what they're growing or selling or using, just know that you will get looped in, because they want to go from the top down, usually.
Right.
Next, talking about two different areas that I think are very important for you. First, Civil Code Section 1954. I pretty much know this one by heart, because there's so many problems that we have come in with tenants and landlords, wherein the landlord wants to enter the property and the tenant doesn't want them to. So if you go to that code section, I would bookmark that if I were you. It gives you a list of reasons why a landlord can enter the property. And there's a whole list. There's actually not a ton of reasons, but they are there for the use of landlords or property managers. The one relevant to this issue would be that landlords can enter if the tenant is violating health and safety codes. So if you as a property manager or the landlord suspect that the tenant is selling out of the unit or growing too many plants or just growing in general, if you have a provision in the lease that says, hey, we don't allow that, you can give notice to enter the property to make sure they're not violating those codes. And the key part about the code section that I always tell my clients is to make sure you give proper notice and that's in writing. There's different ways you can serve it, and we can talk about that more in detail if you have questions. It's personal service, sub-service, or by mail, but mail extends the notice period. Typically it's 24 hours, but sometimes it's more than that if it's reasonable to require more time. Sometimes the tenants have a disability or something, some kind of job where they can't provide access on 24 hours notice, so you have to accommodate that. But I think generally, as you know, in your position regarding enforcement, I think a big concern you may have is figuring out, one, are they doing it in the unit, and two, what do you do about it? So the first step for that would be getting into the property, and 1954 gives you that right. But again, Adam will talk a little bit about evictions and evidence, so to speak, and I think evidence applies to 1954. And just think that if you are going to enter for that reason that I mentioned, make sure you have proof. You can't just say, oh, I walked by the property and I kind of smelled something, and so I gave 24-hour notice to make sure that they're not violating a health and safety code. Have witnesses or have some kind of proof that's tangible, where if the tenant attacks your use of 1954 because the code section says you can't abuse that right, make sure you have something that you can use to show a judge, God forbid you get there, showing that you weren't being unreasonable. Adam, you want to talk a little bit about evictions?
Yeah, so an eviction with regard to violation of the cannabis laws and regulations or any prohibition in the lease can be difficult. It's not a straightforward eviction. It's not like, obviously, a non-payment of rent eviction,
right,
where they either paid the rent or they didn't pay the rent. There's usually not a lot of things to dispute there. Although I'm sure all of you sitting there in the audience know that there's no such thing as a straightforward eviction period. But looking at a cannabis-related eviction, you're going to want to have some body of evidence to support that there's been an ongoing violation of this provision by a particular tenant.
Right.
Quite commonly, you'll see that in the form of other tenants. That's usually how it can come to the landlord's attention. The other tenants make reports of offensive conduct, and so you catalog those. Make sure you're documenting those incidents. Make sure you have those records, and make sure that if it comes down to it, you're going to be able to count on those other tenants to back you up, to either come to court, do a deposition, sign a statement, some type of evidence that this is going on, because it could be very difficult to sort of catch the tenant in the act,
right,
using Civil Code Section 1954. More often than not, you're going to get yourself in trouble for abusing that privilege, because a lot of this stuff is hard to detect at the right moment and come in at the right moment. So more so, you're going to need to try to gather a body of evidence sufficient to evict, based on reports and other documentation of the offensive conduct that's happening in the unit. So it's not enough, again, to just say, well, I've smelled it when I've been walking by a couple times.
Right.
California, as you guys know, is a tenant-friendly jurisdiction. And so, the courts are going to want to see that you've got some pretty objective evidence that this is going on, right, and that you've gone through the requisite notice process and it's not been cured, and so on and so forth.
Yeah, and just the 24-hour requirement in the code section makes it pretty difficult if you think about it, because if you give written notice and they have 24 hours
right,
to get their act together, more than likely they're going to be lighting candles, cleaning things up.
You give the 24-hour notice, and then you hide out front at like 2 o'clock in the morning, so that when they're sneaking out the plants to go put them in the trunk of their car, you see them, doing
that. Could work. A little creepy, but hey, if you're
determined. I'm not recommending that. It's not a recommendation.
So with that sort of gives us an overview of rental advice we have. So we want to get into questions that everyone has typed in. Feel free to send them in now. Also, you can send them to us. We have our emails up on the screen. Don't be shy. We like to help people. So with that, Alexandra, do you want to get going?
Yeah, sure. We do have several questions, a lot of comments as well.
Okay.
I'm getting a couple questions. Will this recording be available? Yes. Tomorrow, I will be emailing it to all of you on the call, and even those who didn't make it today. So look out for that tomorrow around noon. And the first question is, is email a proper vehicle to give notice to a tenant?
I can answer that. Short answer, no. That's a big one. I've probably had 3 or 4 cases come in recently about that issue. If you want to see it in detail, what I mean, go to Civil Code Section 1954, and it gives exact ways you can give notice. It's by hand, by giving it to someone of suitable age that's at the property, over 18, or mail. I get this question all the time, so don't feel bad. It makes sense. Everyone emails nowadays, but that is a very shaky way to give notice, and it's just better to either do it by person. There's other ways to give notice to a tenant depending on what you're doing. If it's a non-payment of rent, there's some posting and mailing options there, but for the majority, I would say email is probably not sufficient for most things.
Yeah. One sort of caveat or dovetail I would take off of that is that the entry code section 1954 also allows for entry by consent. So, if you do have a relationship with the tenant and you email them and say, hey, I want to come, check the smoke alarm tomorrow or whatever it is,
right.
And they say, oh, that's fine, come on over, that's going to suffice. Not necessarily because email notice is sufficient. In fact, I wouldn't term it that way at all, but because you've talked with the tenant and you have tenant consent. So
right.
That may be something to think about as well.
Okay, and the other question here, what do you recommend for handling a tenant who complies with respect to the 24-hour notice, but then goes right back to doing the violation repeatedly?
Well, you've got to make an eviction decision. I mean, that's really the simple answer to the question. I mean, the good thing about that situation, if one could say there was anything good about it, is if you've got evidence of repeated violations, then that's evidence that would support an eviction proceeding, plausibly. I'd have to, of course, evaluate the evidence on a case-by-case basis, but that would seem to be one step closer to that, to an eviction.
Yeah, and just put yourself in the position that you are in court on the day of trial,
right.
And what are you going to show the judge to prove that you were right? So if it's just, you just know that the tenant is evading and they're going right back to normal, it's not going to be pretty in court. As Adam said, courts are tenant-friendly in California, as some of you may know, unfortunately. I would just get some tangible evidence there, and you really have to make a call. I wish we can give you a cleaner answer, make the decision for you, but we can't do that.
Yeah. I mean, the assumption is, I've done a couple inspections, and each time I find, marijuana plants growing in the shower. That's pretty good evidence. If you've got photos of that, if that's documented, and then the tenant's, not responding to your request for compliance, again, subject to compliance with the appropriate notice procedures, that would seem like you could start an eviction.
Right.
And if it happens more than once, get your legal counsel involved or get somebody who's savvy with evictions involved, because, you're going to want to conform your inspection and evidence gathering process with the law. And what I mean by that is that you're going to want to have it be consistent with the notice to cure provisions that are within the code. So, I would think that you could get somewhere with that.
Yeah.
Okay. And would it be a good idea to reference the federal code in the addendum to the lease to back up the ban?
Um, you could. I don't think that it's necessary. It's specifically provided for in the Health and Safety Code that was enacted as a part of California's legalization of cannabis. So you have kind of, I think, more directly relevant and applicable state law that allows for the landlord to make this prohibition. So I don't think you need to go to that level, but certainly I don't see any harm in saying, marijuana is also federally illegal, in your agenda because it is. I'm agnostic on that one. I don't know, Ashley, if you've got any.
It's not required if that's the answer you're looking for. It's a matter of preference. I think it adds some level of
could add some heft,
seriousness to the lease. It just depends on your personality, but you have no obligation to do that.
Okay. And if your city has a no smoking law, actually we have that here in Calabasas, does that automatically apply to marijuana as well?
I would say, well, let me answer your question this way. I don't know. I would have to look at the local provision at issue and see how it's written. It could, it just depends on how it's drafted.
Right.
But there is prohibition in the current legalization law for smoking marijuana in public, and so
you can't do that.
You can't do that. That's already prohibited by legalization. But I don't think people understand that because it seems to me that people are freely doing that.
Yeah.
Just this morning, I got off the Caltrain here in Palo Alto, and there's a guy who typically is on the same train as me, and the first thing he does when he gets off the train every day is, lights one up.
I've seen him.
You see that guy? So part of it has to do with, does anybody in your community particularly care or whatever? But the prohibition already exists under state law.
By law, it's in your home,
right,
or in a business that has a license. So it's pretty limited.
Yep.
And for evicting, can't I use a 60-day notice to vacate instead of evicting them?
Yes, but so there's a distinction to be made there. I can see Ashley thinking the same thing. First of all, it depends on where you are. Are there any rent control laws? Are there any other local laws that would affect your ability to evict on that basis? Or do you need to state a cause? And if you need to state a cause, that could change the type of notice and the way that notice is going to be delivered and what it's going to say, and what the tenant can do to avoid that notice, by the way, in a just cause jurisdiction. But more so also it's going to depend on what kind of lease you have, right? So obviously if you've got a fixed term lease, 60-day notice isn't going to cut it. It's not going to work for you.
Month to month.
Right. If it's a month to month tenancy, then probably, yeah.
But regardless, if you do 60, 30, 3, if the tenant doesn't leave when they're supposed to, you're going to have to evict anyway. So notice and eviction are two separate issues. Notice is the type of violation or the reason why you're getting them out, and then eviction applies to everything. So separate those two and really just focus on notice to start, and then you don't have to worry about eviction unless they don't leave. And that applies to everything.
Right. Yeah, so for the 60-day notice, it's theoretically possible if you're in a non-rent control jurisdiction with, a month-to-month tenant, then a 60-day notice would work because you don't need a specific reason to serve that notice. But again, all that notice does, if you want to get legal about it, all that notice does is serve to terminate the tenancy.
Right.
And so the tenancy is terminated after 60 days, but you still cannot physically remove the tenant from possession of the premises, right? No self-help.
Don't do that.
Do not lock them out. You've got to go and evict them anyway. It doesn't matter that they've overstayed the 60-day notice.
Right.
That 60-day notice is just your prerequisite to filing a court action if you have to.
Okay. And just have one more question here. What is a provision? You mentioned that several times.
Sorry, what is what?
A provision.
Oh, a provision.
A provision? Oh, a provision is an element of the law. So a code provision would be, basically one of the numbered elements of the code. So, for example, Ashton's talking about Civil Code Section 1954. So that would be a code provision.
Right, or a provision in the lease.
Right.
That type of thing.
Yeah, it's often used as a way to refer to a clause in the lease.
Right.
Okay, well, that clears that up. And those are all the questions that we had so far. So, for those of you still on the call, again, recording will be sent to you tomorrow. Adam and Ashley, if you could send me the PowerPoint, that would be super helpful. We could send that as well tomorrow. And if you have any questions at all, Adam and Ashley, I already said it, please reach out to them. Their contact info will also be in the email I'm sending tomorrow. And before you leave, please take our exit survey. I'd love to hear your thoughts on this webinar, suggestions for the future ones. Did you like the video? Do you not care? I think it's great. I'm really glad you guys did it. And again, thank you so much. I learned a ton. This was super interesting, and I hope to have you guys back again. Actually, you guys are on the schedule again soon. I'll also tell you guys on the call when they're going to come back. Hopefully, we can get your dates worked out. I know you guys are busy, so thank you again for making the time.
Thank you.
Happy to do it.
All right. Have a great day. Bye.
Thanks.